May I please, Your Lordship? Lordship, I beg to mention item number 18 from supplementary list. It was a part-heard matter, Your Lordship.
It was yesterday's matter where the material witness was not examined. But the counsel is really, she's sick. She couldn't make it in spite of her best efforts. So, will Lordship can take it up tomorrow? She's taking medicines. Because Lordship has already heard bench is there only for tomorrow.
All right, tomorrow. But tomorrow we'll close it.
Yes, sir.
Please tell her if she's not available, then you argue. We have heard her already.
Lordship, yes. Lordship has heard.
That was only on the point of non-examination of.
The wife.
So we have found that there is nothing to show that the wife was present at home. There is no evidence.
Present at home.
Yes.
Yes.
So if there is nothing to show that she was present at home, it is doubtful whether there was any scope for examining her also. That anyway, tomorrow we'll
Yes.
close it and
Lordship.
order will be passed tomorrow.
Lordship.
Please tell her. If she is not there, we'll hear you and close it. We have already heard her arguments. Item 18 you write it
Yes, sir.
on the request of learned legal aid counsel, Mrs. S. Roy. This matter is directed to be posted again tomorrow. That is with the date for hearing as a fixed part-heard matter.
May I plead your lordship? I beg to mention for listing lordship, II criminal in criminal appeal number 18/1024,
Fresh matter.
fresh matter
Next week, next Wednesday.
with much obliged.
Lordship, similar prayer, Lordship, for hearing, Lordship.
Hearing.
Lordship. Ready for
Get
hearing.
it for orders and get an order from the clerk.
May it please, Your Lordship.
Listing for orders.
Lordship.
Lordship, we filed an additional affidavit yesterday in connection with item number 2 of the daily list. Lordship,
Yes.
I kindly call for that to be tagged along with the record.
Yes.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 5, Lordship. Protecting counsel, Mr. S. Bhattakur could not prepare his Lordship, and he needs some time, Lordship. May kindly please.
On the request made on behalf of the appellant's counsel, Mr. S. Bhattakur, seeking further time to prepare and argue the appeal. Hearing of this matter stands adjourned for 2 weeks. Please accordingly.
Keep the.
Day minutes for hearing item 1.
May I please, the Lordship? Well, this is, this matter was earlier remanded back, my lord. And thereafter, my lord, one of the accused was acquitted. And my lord, here, my lord, the appellant before Lordship, my lord, has been convicted, my lord, his conviction has been sustained, my lord. My lord, he is Mr. Samal Pal, my lord. And my lord, basically, my lord, it's based with the circumstantial evidences, my lord, basically based on extrajudicial confession, my lord, and recovery of the body, my lord. Now, here, my lord, the extrajudicial confession, it doesn't appear to be, my lord, a voluntary one, number one. And secondly, my lord, so far as section 27 is, my lord, concerned, my lord, the recovery of the body, relating to recovery of the body, my lord, the procedure has not been followed at all. My lord, there is no, my lord, identification of the body, my lord. There is no witnesses, my lord, while, my lord, examining the witness, my lord. Sorry, my lord, the accused, my lord, when the statement was recorded, my lord. My lord, while recovering the body, there was no witness, my lord, taken, my lord. My lord, even the statement which was recorded of the, my lord, accused, my lord, that is also not been, my lord, there's no evidence on that also, my lord. But allegation, my lord, FIR Lordship will find at page 4, my lord.
Yes.
Lord, this was lodged by, my lord, the brother, my lord, of the deceased, my lord, Uma Pal. My lord, with due respect, I would like to inform you that about 12 years ago, the below mentioned accused number 1 married my sister, Uma Pal, as per social customs and traditions. As no child was born to them, the accused number 1 used to torture my sister physically and mentally and threaten to kill her. Accused number 1 is my brother-in-law, entered in another marriage, beginning second marriage, and he, along with his second wife, started torturing my sister with more intensity. On 24/10/2011, well, this FIR was lodged on 4/11/11. The above mentioned accused duo, with the assistance of accused number 3, took my sister to Orang on the false pretext of providing medical treatment to her there, And since then, my sister has gone traceless. When I, with the help of local people and BTP secretary, Binoy Krishna Pal questioned the accused persons, they confessed that they had killed my sister and buried the body inside a jungle near Orang Tea Estate. Therefore, I request to investigate the matter and take necessary action in this regard. Now, my lord, he deposed, my lord, as my lord, then my lord, charge sheet was, my lord, under section 120, 302 and 201 and 34, my lord, against all the accused persons, my lord, were, my lord, framed, my lord, with the police, my lord. Then, my lord, lordship will find the evidence of PW1, my lord, Bibhas Pal, my lord, the brother. That is the informant, my lord. I know the accused persons. Around 22 years back, my sister was married to Shamal Pal. No child was born to my sister. Therefore, Shamal Pal used to torture my sister. He also threatened to kill her. Shamal Pal remarried Sumitra Pal. Thereafter, Shamal started torturing my sister with more intensity. On last October 24, the accused duo took my sister to Orang on the pretext of getting her medically treated. Then the accused duo killed my sister and buried her body in the jungle at Orang. When my sister did not return home, Shamal's elder brother Durgapal came to our house and informed that Uma had not returned to the house. I informed BDP secretary Vijay Krishna Pal. Vijay Krishna Pal told Durgapal to search for Shamal. Durgapal found Shamal. Then he said that he, along with Sumitra, had killed Uma. It was the day of November, that day. I immediately lodged an Ejahar with the Orang police station. Exhibit 1 is the Ejahar, Exhibit 1 is my signature. The accused confessed at Dekejali police station that they had killed Uma. At that time, I was present there. Samal stated to police that he had planned to kill Uma during the Durga Puja, but there was a lot of people around. He temporarily suspended his plan. Shamal showed police the place where he had kept the dead body concealed. Accordingly, the police recovered the body. The Ejahar was written as per a version. During her lifetime, Uma Pal did not lodge any case in connection with Shamal torturing her. After his second marriage, Shamal kept Uma at his house at Alisingha. Shamal lived separated at Orang. Shamal has 3 brothers. I lodged the FIR on the basis of the information received from Durgapal. I gave my statement to the police. It is not a fact that I have falsely deposed that I was present while accused confessed his guilt at Dekejali police. Now, my lord, PW2, my lord, is Binoy Pal, my lord, who is the VDP secretary. I know the accused duo. I was the VDP secretary at that time. Then I was at home. When Durgapal came to me and informed me that Uma had not returned home, I went searching for her, my lord. There is nothing to state, my lord, when they went for searching for her, my lord. Nothing, no dates are mentioned, my lord. About 7, 8 days thereafter, Durgapal apprehended Samal Pal and brought him to my house. On being questioned, he replied he killed Uma Pal. I handed over Shamal Pal to the Dekejali police. I informed Bibhas Pal. Then he was sent to Orang PS from Dekejali PS. Bibhas lodged an Ejahar. Durgapal said that though Shamal took his wife with him, Shamal came back alone. When Durgapal and Shamal asked Shamal about Uma, Shamal replied that he had sent her to house. I heard these things from Durgapal. I did not state to the police that Shamal confessed before me, as police did not ask this to me. Then, my lord, PW3 is Durgapal, my lord, who is supposed to have given all the information. This is Uma Pal is my sister-in-law, wife of my younger brother. Shamal is my younger brother. Shamal's wife was bitten by a dog. In order to provide treatment to Uma, Shamal called her to Orang. On that day, I did not find Uma at home. When I came back, on being asked, Shamal replied that he had sent Uma. Then I made inquiry in the house of Uma's father, but did not find her there too. Shamal lived in a rented house at Orang. I did not find Shamal there. After some days, I found Shamal in a house of a person Subud by name near Dhansari Ghat. When I asked him about the whereabouts of Uma, he had replied that he had killed Uma. I took him under seizure and handed over to the VDP secretary. Now, Uma has been staying in our house after the remarriage of Shamal, and Shamal had been staying in rented house in Orang. I did not lodge Ejahar with the PS when I did not find Uma. I was alone when Shamal told me that he had killed Uma. There was none with me. We are three brothers. We have 1 bigha of land. Shamal also have a share in the land. I do not know about the second marriage of Shamal. I do not know which place his second wife belongs to. Uma and Shamal have been living separately for about 3 years. Shamal used to visit the house of frequently to look after his parents. I was not present at the time of recovery of the dead body of Uma. I did not go to the rented house of Shamal at Orang prior to the incident. I gave my statement to police. It is not a fact that I said to the police that when I asked Shamal Pal in threatening language, he confessed the guilt before me. He did not tell me where he had kept the dead body buried and other things. It is not a fact that I made threat to Shamal. He confessed before me that he had killed Uma out of fear. Then Milord one Siddhen Pal. He is the nephew of Milord Shamal. I know the accused. Shamal is my nephew. One day Durga Pal told me that Uma had not come back to the house. I asked them to search her. After some days, Durga Pal came to my house taking along Shamal. In my presence, when Durga Pal questioned Shamal, the latter confessed that he had killed Uma. I called the VDP secretary Binoy Pal and handed over Shamal to police through him. I told police these things. Prior to bringing Shamal to my house, Durga Pal informed me that Uma had gone out of the house but did not come back. Shamal did not tell how he killed Uma and when and where he had buried the dead body. PW file is on Sunil Pal. I know Vibhas Pal. The incident had taken place during Kali Puja, about 5-6 months back. On one day while I was in the shop, Durga Pal told me that he had brought Shamal under apprehension. I asked Shamal Uma was. He replied that he killed her. I called VDP secretary Binoy Pal and informed him about the incident. Shamal told Binoy Pal that he killed Uma. Binoy handed over Shamal to the police asking me, police asked me nothing. Durga Pal is my uncle's son. Durga Pal told me nothing when he had brought Shamal under apprehension to my shop. I did not know why he was brought under apprehension. I did not go to the PS when Shamal was taken to the PS. I don't know what had happened. And after he was taken to the PS. PW6, my lord, is the IO, my lord. On 4/11/11, I was working at Orang police station. At about 6 p.m., the OC received an ejahar from the informant Vibhas Pal. He entrusted me with the charge of investigation. Initially, informant handed over the accused to Dhikiajuli police station. I brought the accused from the Dhikiajuli PS. As shown by the accused, I had recovered the body. I had sent the body for post-mortem examination. I examined the witness and prepared a sketch made of the PO. At the end of the investigation, I submitted the charge sheet against the deceased duo. The incident took place on 24/10/11. Shamal showed the dead body. It is not mentioned in the charge sheet that I recovered the dead body on being shown by Shamal. Boundary of the PO is not mentioned in the sketch map. The dead body was found laid on the ground and covered with branches and leaves of tree. I did not seize anything from the PO. I did not collect footprint and other things. As there is no habitation near the PO, no one was examined. I did not make any search in the rented house of Shamal at Orang. No blood was found at the PO. Shamal Pal, Sumitra Pal, and Sudhir Pal were named in the ejahar. Shamal Pal was not sent for recording his confessional statement. Inquest was held at the PO itself. There are no witness to the inquest. No one from Dhikiajuli PS was made witness. While giving statement, witnesses Vibhas Pal did not state that he was present at Dhikiajuli PS while the accused duo confessed their guilt. Witness Durga Pal stated to me that when he asked Shamal in a threatening language, he later confessed the guilt. The later confessed the guilt. Well, the PW7 melod is the doctor melod conducted the post-mortem melod. On 5/11/11, while I was working at the MNHO1 at Udalguri Civil Hospital, I performed the post-mortem upon the dead body of Uma Pal, 35 years. The body was identified. On examination, I find the following. Now, my lord, opinion, my lord. In my opinion, death is due to asphyxia following strangulation. Exhibit 2 is the post-mortem report. Exhibit 2 is my signature. The body was totally decomposed. The muscles were separated by bone. I do not know what position the dead body was found. It is not a fact that the death was due to asphyxia and as a result of strangulation. I could not detect whether C2 fracture was antemortem or not. Now, in the 313 statement, my lord, he has denied, my lord, everything, my lord, including whether he had taken, my lord, her to Orang. then my lordship will find, my lord, the judgment, lordship will find, my lord, at page 34, my lord. The case was taken up for rejudgment as per order of the Honorable High Court in criminal appeal number so and so against accused Shamal Pal. In the criminal appeal, Honorable High Court was pleased to acquit Sumitra Pal. Honorable High Court also directed to record the evidence of the doctor who performed postmortem examination of the dead body on the deceased Uma Pal and write a fresh judgment in accordance with law. As per direction of the Honorable High Court, Dr. Orindam Bora, who performed postmortem examination of the dead body, the deceased was examined as PW7 and write the judgment as fresh as follows. My lord, he has narrated the incident, my lord, and then, my lord, the decisions are, my lord, from page 37, my lord. The points of determination. Whether the accused in furtherance of the common intention agreed to kill Uma Pal, and for that they brought Uma Pal to Orang on the pretext of providing medical treatment to her, and thereafter killed her. Whether the accused in furtherance of the common intention committed murder of Uma Pal, and whether the accused in furtherance of common intention concealed evidence of the murder of Uma Pal in order to screen the actual offender. In order to prove the offense,
Mr. Datta, where is that order of the High Court by which it was?
that is not in the paper book, man. That's not in the paper book, man.
And one of the co-accused was acquitted.
Acquitted, my lord. The wife, second wife, my lord.
Will acquit. Have you preferred an appeal against that order?
Lordship against order of acquittal,
It can't.
because lordship allegation as such,
Listen. If the matter is sent for retrial,
my lord,
one of the accused cannot be acquitted. If you accept that position, we'll acquit the present appellant also. That is
lordship,
technically.
lordship, I may be given the opportunity to go through that judgment once. Could you have overlooked that?
If no appeal is preferred by the state against that, then the present appellants will have to be acquitted and will record that it is due to conscious lapse of the state. We have no option. We don't know what is the order, but unless there is some reason given, the order which on one hand acquits one of the co-accused and on the other hand asks for recording evidence and retrial, both can't happen. Both cannot happen. We don't know what is there in the order.
Lordship, let me have a
Both
look,
the
my
things
lord,
can-
because it probably in that matter, doctor was not examined,
Maybe,
maybe,
but then that means the whole trial was reopened.
issue.
Then how can somebody be acquitted? Unless the judgment is interdicted, there is no question of fresh evidence and rewriting judgment. That means the earlier judgment is gone. The earlier judgment is gone. Where is the question of?
Let me have a
acquittal?
look at the order. The next week it will be
Things
taken up.
happening, Very sorry to say. We would also like to see that judgment.
Right.
Yeah. Must be a coordinate bench, difficult to.
Right.
But on the face of the record, this is totally erroneous. And by recording that, we'll give acquittal to the, nothing can be done here. Everything is going on in a very, very shabby with the list. First of all, in a murder charge where the dead body is recovered, how did the learned trial court not examine the doctor, postmortem conducting doctor? So the serious misconduct. Would also like to know who is that judge. What kind of grade 1 officers are we having here? But in any case, judgment sent back for rewriting, that means the earlier judgment is gone. The earlier judgment is gone, the conviction of all the accused is gone. Then there is no question of acquittal. If one of the accused has been acquitted, that is in our view, we can't say much.
Lordship, I'll go
And
through.
if that erroneous position has been accepted by the state, it will apply to this accused. No other discussion will be. Have it tested before the state. You can't do this. Accept a judgment where one of the accused is acquitted. The judgment of the trial court is set aside. Where is the conviction then? Where is the question of acquittal? Find out where is that judgment.
Some
I'd
other
like to
thing
have a
will
look
taken
at
up,
that
my lord.
judgment.
The coming week it will. 83G. 83G of 2012. Criminal appeal.
Just give the number earlier.
I've given 83G, minor.
If it is there, then. High Court
High
judgment.
Court or criminal appeal 83J.
It has to be in the LCF. Ms. Bhuya.
Oh.
It has to be in the
Bus, I
LCF.
know. Hmm.
Consider after disorder the development.
Got it. Got it. I want to go through it, my lord, it may be taken up.
Give it to us first.
83G, PK Saiti and Indira Shah. 83G. Two 2012. Advisory. लिखो ना अब वो पीके सत्या इंदिरा शर्मा पुराना पुराना ना जेरोक्स का पड़ा यहाँ पर जेरोक्स को my lord.
Yeah, you have a little work in hand. You have to address the court. How a matter can be remanded for fresh decision without setting aside the original order. We have not heard of that. If the original order is set aside, then that means the order has to go in toto. Half the order can't be set aside. That is a matter of simple common sense. So if the original order is set aside, then how can one of the co-accused be acquitted? address us on that. The state has not preferred any appeal.
Lordship, I'll go through the judgment once. No, it's not uploaded. May I get a copy? Yeah. Copy, my lord? No, photocopy? Ah. I'll get a photocopy and I'll do it in the next week, your lordship.
Twelve or 23 unconvict one accused and acquit other than. So. In September.
Lordship,
Try tomorrow.
tomorrow.
Certain things happening. Have you understood the point?
Yes, my lord.
You want to remand the matter for retrial, you have to set aside the judgment. Even if there is no express order, it will be deemed as set aside. If the judgment of conviction is set aside, then where is the question of acquittal of one of the co-accused? So there is no acquittal.
My lord.
This retrial is vitiated. It has to again go back. Now, if the other accused is acquitted, without hearing her, no order can be passed.
Yes.
And these are things the state has not pointed out anything. We are not telling anything to you. Considering the time lapse, he's in jail.
He's in
Since
jail.
when?
Almost 11 years, man.
On that ground.
Okay, I'll try it tomorrow.
Try tomorrow. Tomorrow. Yes, sir.
There is one judgment, it was cited in section.
Yeah, what is the judgment?
Yeah.
So, Mr. Datta, you are appearing as an amicus, you know. Is it, are you an amicus or
My amicus, man.
purely on a technical ground? Otherwise, purely on a technical ground, this might lead to acquittal. Unless you
Well-
tell us tomorrow why it should.
Well.
We have to mention that this is the order which has not been assailed by the state. So there is a clear acquiescence on the part of the state.
Lordship's voice is not coming up properly.
We'll say that
Yes,
the order was not assailed.
my lord.
This were the lacuna, perhaps,
I
the
know.
process, but the state has not assailed. So the state has acquiesced in the process. Then the benefit has to go to the other appellant as well. An order of acquittal without an appeal against acquittal cannot be set aside. So on the same, whether doctor says it's a homicidal death or not, in a conviction under 302 read with 34,
Ready,
you-
201 was also.
201. How do, if you accuse one of the co-accused, the matter is over and the state accepts it. This is a
Against the instant appellant.
it's a 1.5 page judgment here, nothing more.
My lord.
Just 2 pages, matter is over. But you go through it and tell us what is it. We hope you have understood the
Yes,
point.
yes, yes.
And we understand the processes are not perfect. But then there will be a price for imperfection. He has been in the jail 11 years, that's enough. Where is the decision that on same set of evidence, if a co-accused is
My
acquitted?
lord, this is one of Javed Shaukat Ali Qureshi versus State of Gujarat, my lord. This is a judgment of 2023, my lord.
What is the citation?
Citation, my lord, I have the live law citation, my lord. 2023 live law SC 782.
Right.
You are a copy of the order, division bench order from the LCA.
Yes. That in a way I've done. Citation plus.
And please flag mark that order also. All right, we'll have it tomorrow then.
Tomorrow, my lord.
Pathak, next Pathak.
Item two.
Please, your lordship.
You'll be able to finish it today.
Yes,
We'll
lordship.
not keep it part-heard because the bench is not available next week. And for how long, we don't know. This bench.
Lordship. It's a
Medical difficulties today.
Huh?
Actually, I'm not keeping well today.
You're not keeping well.
Really was sugar fall down in the
Huh?
sugar fall down in the morning.
In this matter relating, we have filed an application for determination of the age in a juvenile lordship. So
Sure. Today you want to press the IA.
I also and lordship if consider the I then whole matter. will
You have to make up your mind. What do you want to press? The IA or
Because the
the appeal?
report is there, lordship. Already report received by this honorable court.
Hmm.
First, lordship, in this case, one ossification test was done. And after receiving the report, this honorable court heard the matter and that order, though passed by the trial court, that was not under any provision. That is why again send back this matter to the trial court. Trial court again conducted the inquiry, lordship.
Hmm.
And after
Just a minute, just a minute. What is the date of occurrence?
date of occurrence is lordship 29/7/2016.
So according to you, the applicant, he was the sole accused person or
Yes,
others were there?
I'm the sole accused
Sole
person.
accused.
Yes.
What was his age on that day?
As per 313 lordship, on the date of recording the statement, he was 18 years. Because there is no document to that regard, that is why ossification test done.
So on the date of occurrence, what was his age?
On the date of occurrence, he was 16 years person. 313 to ossification.
Now, which is the order by means of which?
Order lordship, order dated.
Here is the latest report from the learned additional session number 1. Lordship.
5/4/2018 lordship.
Sorry, 5?
4/2018. It was the first report received by the by this honorable court.
There is an order of 18 to 2021.
Before that, lordship, one report received by this honorable court.
That is gone, that is gone.
That is,
Yes.
but to that regard, I have one submission, lordship. As per, it is covered by the old act, not by the new act, because it is a case dated 29/7/2016.
But
And the
then-
rules come
but
into.
then you have to apply for a modification of this order.
If-
Once there is an order, this order was passed after hearing the council,
Yes, sir.
18 to 2021.
Yes.
Please read the order. Let us see what is there in the order.
Edit to 2021 in criminal IN 116/2018.
So what is the report in terms of this order?
In terms of the order report received at Lordship on the date of occurrence, he was 18 years. Because there is a variation of date about he was at the time of conducting the ossification test, he was 25 years lower limit and the upper limit is 35 years.
There is a report of 12/6.
Yes. 12/6, 12/6, 12/6. It was- But Lordship, after that, Lordship, as why I mentioning that it is covered by the old act, the Lordship, because the occurrence took place on 29/7/2016, and the new act rules come into force in the month of September, Lordship. So all act rules, all act will follow in this case, Lordship.
Why,
So
why do you say so? Is there any ruling on that?
Yes,
Yeah.
that is why, Lordship.
Show us the ruling.
Lordship, take it away. Because also if we'll follow that, then only we'll get one more year regarding that. If 18 years considered by the trial court, then another year will get Lordship.
No, that is correct, but
There is
listen, please
Lordship,
listen.
Lordship.
The law which is in force on the date of age determination, will that hold the field? Or the law which was in the force on the date of occurrence will hold the field? Do you have any judgment, any authority on that point? Merely because you say so, we cannot accept it, no? Either this has to be the point of hearing and detailed hearing and judgment. Then, depending on what the court holds, either your submission will be accepted or rejected. Or there has to be a pre-decided authority by a superior court. Do you have any authority in your favor?
Lordship, Act says so, Lordship. Regarding that. In New Act.
Which act?
New Act, Lordship. New Act rules.
I was given a list of books. I was
Can I-
given the list of books.
List of books. List of books.
JJ Act.
List of books. দেয়া কথা এটা মই রাত্রিতে করে এখন বনার পেয়ে দিব
Just a minute.
আচ্ছা juvenile justice act rules to তোমাকে বলছি।
ভুল মর্যাদা হচ্ছে স্টেট প্রবলেম কোনো পুরোনো ব্যাপার আছে টোয়েন্টি 24 নাই
So it is found that he was major on that day.
That is why lordship is as per this lordship rule 12.
Hmm.
Rule 12 provides your lordship.
No, you are not probably understanding one thing.
Lordship.
This process was conducted as per order dated 18/2/2021. Is it not?
yes
This order clearly lays down which process is to be followed. This was passed after hearing both sides.
Order dated 21/2021.
18/2/2021.
18/2/2021.
Hmm.
I filed 116/2000 in criminal appeal number 116/2081. Lordship, that is after hearing pass this order. But Lordship, in this case, the occurrence took place, Lordship, on 29/7/2016. From the date of occurrence, this.
You are running a high risk. Either you are deliberately not understanding the query.
No,
or
Lordship,
you
that
are
is not
not-
true. That is not true, Lordship.
This is final. You have to challenge it before the Supreme Court. Because the High Court has passed an order hearing both sides, given a direction which process is to be followed.
Correct, Lordship.
By following that process, they have conducted age verification.
Yes,
Submitted a report.
Lordship.
That report says your client was aged about 18 years, 3 months, 1 day.
Yes,
on
I
the
agree
date of
with that.
If you agree, then
Then Lordship, but Lordship, 1 year, 1 more year you will get Lordship. As per Rule 12.
no, because his age was found to be 20 years.
That is, your Lordship, kindly come to Lordship, Rule 12, Lordship.
Rule 12. Rule 12 of
Rule 12 of Juvenile Justice Act, Lordship. The rules, 2007, Lordship. Procedure to be followed in determination of age.
Rule 12 of which rule?
12, the rules 2007.
2016 will be applicable because direction was in terms of the new act.
No, Lordship, 2007 rules, Lordship, at the last line. Rule 12.
That's correct.
Madam, as per order dated 18 to 2021, last line, last paragraph, Lordship. This should be conducted as per Juvenile Justice Care and Protection Child Rules 2007. If it is 2007, then I will get 1 more year, Lordship.
Where is that order?
Order 18 to 2021, last paragraph, Lordship. In IA 116 2018.
I
116 2018.
order dated.
Order dated 18 to 2021. Last paragraph, Lordship.
Which provision of 2007 rules?
I would like to place this rule 12B.
Rules are not here.
Rule 12B, Lordship, may I read?
1 minute. We don't have the 2007 rules.
It is 2000, I have the 2010, Lordship, period is on.
Check. 2007 rules were repealed on which date?
Repeal on Lordship, as per new act, Lordship. This new act come into force as per rules, Lordship, come into force 21/9/2016.
No, the date.
21/9/2016. Our date is Lordship 29/7/2016. Before 2 months. Of
1 minute.
this
It was
coming-
repealed on?
repealed on Lordship earlier one. It is coming to force new act 21/9/2016.
So the occurrence took place when the 2007 rules were in force.
No,
Then
2007 imposed, Lordship. This is the rule. I have one copy.
but when the order was passed, 18/2/2021.
That day also, this honorable court directed to follow rules to 2007 Lordship. At the last paragraph, Lordship. As per that,
Correct,
Lordship,
correct. So as per 2007 rules, what is your submission?
my submission, if he is considered by the trial court, he is 18 years on a date of occurrence. Then Lordship, I'll get one more year, Lordship, as per 12B. I have one copy only, Lordship, last night.
Why didn't your juniors give the list of books?
I'm extremely sorry, ma'am.
We may not be able to conduct your case today without the books.
B, Lordship, last. As per Asin Kumar also, Aswini Kumar Saxena and Dargaram.
So that is it, lower side with a margin of 1 year.
Yes,
So they found his age to be 20 years. But the opinion said, we'll give him a margin on the lower side, maximum of 2 years.
that is your Lordship, kindly peruse this. I have placed two citation, Lordship. 2015 to SCC and then 2012 9 SCC, Lordship. As per that, after giving 2 years, one more year you will get as per that, Lordship.
Let us see.
Lordship. Lordship will find in 2012 first, 2012 9 SCC 750, Lordship. Asin Kumar. Sorry, Lordship. Before that, 2015 to SCC 775.
Yes.
Lordship. 775.
Which para?
Lordship. Lordship will find at page, paragraph number 16 and 17, Lordship. Ma'am. My dear, my dear. May I read, Lordship?
Yes.
The medical opinion given by the duly constituted board comprising professors of anatomy, radio diagnosis and forensic medicine has determined his age to be about 33 years on the date of examination. The board has not been able to give the exact age of the applicant on medical examination, no matter the advances made in that field. That being so, in terms of Rule 12(3)(b), the applicant may even be entitled to the benefit of the fixing his age on the lower side within the margin of 1 year in case of the court considers it necessary to do so in facts and circumstances of the case. The need for any such statutory concession may not, however, arise because even if the estimated age as determined by the medical board is taken as the correct or true age of the applicant, he was just about 17 years and 2 months old on the date of occurrence and thus a juvenile within the meaning of that expression as used in the act aforementioned. Having said that, we cannot help observing that we have not felt very comfortable with the medical board estimating the age of the applicant in range of 30 to 36 years on the date of medical examination. The general rule about age determination is that the age as determined can vary plus minus 2 years, but the board has in the case at hand spread over a period of 6 years and taken a mean to fix the age of applicant at 33 years. We are not sure whether that is the correct way of estimating the age of the applicant. What reassures us that about the estimate of age is the fact that the same is determined by a medical board comprising professors of anatomy and radio diagnosis and forensic medicines whose opinion must get the respect it deserves. That apart, even if the age of the applicant was determined by upper extremity limit 36 years, same would have been subject to variation of plus minus 2 years, meaning thereby that he could be as well be 34 years on the date of examination. Taking his age 34 years on the date of examination, he would have been 18 years, 2 months, 7 days on the date of occurrence. But such an estimate would be only an estimate and applicant may be entitled to additional benefit of 1 year in terms of lowering his age by 1 year in terms of Rule 12(3) to B Chopra, which would then bring to him to be 17 years, 2 months old, therefore a juvenile. And 2000, Asin Kumar. Then Asin Kumar also there 2012 minus you. Minus issue to KG. Extra copy.
So according to you, which of the rules will be applicable here? The 2007 or the new rules?
2007, Lordship.
2007.
7.
Why? Because the occurrence took place when that rule was in.
Or that should be considered, Lordship.
Why do you say so? Is there any authority on that?
Because it was not in force at that time of occurrence.
Sorry, we can't accept this. You have to argue, then we'll have to hear the whole matter. Just one sentence will not do. Then you argue to show us that this is the law. This is how the law is to be interpreted.
But Lordship, in criminal law, it is no, there is no retrospective effect, Lordship. That is the thing, Lordship. Rules come into force.
What is
after
your stand,
occurrence.
Mr. Kyle?
Lordship, even his because as per the court's report, his age was 20 years, then he was given benefit of 2 years. Even if it is less than 18 years, in case of heinous crimes, Lordship, that benefit cannot be accepted to the petition law.
Any judgment to
Yeah,
that?
there are many judgments to that effect.
Then show us. She has made her arguments. Show us.
Lordship, I can place the judgment, but copies are not with me. I'll read out slowly and I'll supply the copy to your lordship. Lordship may fix a date. I'll
It's a juvenile case. If Lordship, he has not copied and fixed tomorrow, Lordship. It's juvenile.
Heard Miss S.K. Nargis, my counsel appearing to the applicant on the request of Mr. S.C. Kyle. Counsel appearing for the respondent. When do you want it?
Tomorrow, Lordship.
next
Okay.
witness,
Huh?
next Thursday or Friday.
Lordship, kindly tomorrow, Lordship already heard, Lordship.
On Tuesday.
Let the matter be pardoned, Lordship.
Yes.
Obliged, Lordship.
But it will not be heard before July. If you make it part heard after reopening of summer vacation. Agreeable to that? Huh?
I agree with that, Lordship, because Lordship heard all the matter.
No,
And-
that is another matter. This bench will not be available for another 2 months from next week.
Let's be pardoned, Lordship. Let's see, Lordship.
List it on Tuesday, that's all. Good bench you will get, don't worry.
Item 3 and 4.
May I please,
I'll-
Your Lordship?
It's an appeal against conviction, my lord.
Your
Under
Lordship,
section,
Yes, yes.
sorry, Your Lordship, Mr. Engaged Counsel, Mr. Jadalam is out of station, Your Lordship. Kindly matter be part heard, Your Lordship, because on Monday, the date may be fixed.
This is an appeal against executive and he is against conviction.
Item number 4 is appeal against acquittal, Your Lordship, and item
That's
number
all.
3 is
altogether 4%, my lord.
Yes.
One has been convicted, rest are acquitted.
acquitted, Your Lordship.
And she is appearing from the acquittal, my lord. Appeal against acquittal. And
Yes.
mine is the conviction, my lord.
So what to do?
Otherwise, I am ready, my lord, very small matter. Otherwise.
No, but both the appeals have to be heard together.
Yes.
See, we could have started, but there is a problem. This bench is not available next week. And we don't know when it is available. So making matters part-heard will be difficult. What is the point in hearing you? We have to give the judgment after hearing the other side. These are operational difficulties. Mr. Bora,
I have no option, man.
neither do we have. What to do?
Your Lordship, kindly matter be adjourned to the Your Lordship.
Let it go. After 2 weeks,
Date may be fixed, Your Lordship.
Mr. A.M. Boral and his senior counsel is present on behalf of the appellant in item 3. You are the appellant in item 3, is it?
Yes, sir.
However, a prayer for adjournment has been made on behalf of the appellant in item 4 on the ground that the learned arguing counsel, Mr. Z. Alam, is unavailable today. Ms. S. Jahan, learned APP Assam, present on behalf of the state. Please, both the matters are tagged together.
Try to prepare question answer. Why do you?
One of the appeals cannot be segregated and taken up for hearing and disposal today. In view of the above, this court is left with no option but to adjourn the hearing of both these appeals. So what are weeks? At least let the appeals be listed again for hearing after 2 weeks. After 2 weeks, Mr. Bora, after
Vale.
2 weeks.
Deeply obliged. Your Lordship.
Where is Mr. Kyle? Mr. S.C. Kyle is there? Can you call Mr. Kyle? Ms. Nargis? Call him, we'll give it a chance tomorrow, your matter. Because yes, you are right, we have heard it for a little while. Whatever the outcome, call him.
Item 6.
To next week, no koi kali.
Item 6.
Item 6, Mr. Mondal was here. He was telling me that while shifting his chamber, he lost the file. But now he is not here. He will have to reconstruct. Mr. Mondal was here.
May I please, Lordship, 1 week time will be granted.
1 week time.
Yes.
The prayer of learned counsel for the appeal, hearing of this appeal stands adjourned for a week. Ms. S. Jahan, learned APP Assam, is present on behalf of the state.
Obliged.
See matter to Kali Lava, juvenile of the. Come on. You are there in that, Ms. Jahan, you are there in the juvenile that matter, Ms. Nargis case.
This is actually NCP, so we are not there.
Why don't you just give us some assistance?
Yes,
tomorrow?
yes. In fact, she was asking me. Yes.
Yes.
In fact, in the 2000 Act itself, it is said that whatever pending proceeding will be considered as per the old Act. But I have not checked 2015 Act. I'll have to
Just
check.
check tomorrow, just be there
Not-
when the matter is there.
I'll assist.
Because it's a plea of juvenility, so yes, we have heard the matter a little
Mm.
while. It will not be fair to push it to another bench. Even if Mr. Kyle doesn't find enough sugar by
Yes.
tomorrow morning, you
He
see
can
if you can
come.
add some salt.
7.
Accused appellant is on bail, 15 years of conviction, he is on bail. And she is not ready.
Even
She
after
is
vacation though.
I
she
could
is
not
not
see
ready.
the
That's the
file.
thing. She is also not ready. That's why.
I have seen the AM Bora's matter, but I've left this, couldn't find time.
Mr. D. Talukdar, learned counsel is present for the appeal. However, on the request of Mrs. Jahan, learned APP Assam, appearing for the state, hearing of this appeal stands adjourned for 3 weeks. 3 weeks or 4 weeks?
4 weeks
4 weeks.
after vacation in July.
He's on bail.
He is on bail.
Item 8. Live to copy দিব
Portnalai.
It's not lucky for him. Then let it.
Second week of June, any day it will come.
Six.
Yes, Mr. Bhattakur, you are there?
Lordship,
You are also not okay with 4th of June?
no, your Lordship, 4th of then I am okay with 4th.
So why don't you agree on a date?
Let it. Or sixth, your Lordship. Sixth.
The joint request of learned counsel appearing for all the appellants made with the consent of the learned APP Assam, that these appeals be listed for hearing again on 6th of June 2024 as fixed items.
Obliged.
Item 16 and 17.
If 16, 17, that's a matter relating to NDPS, they were convicted.
Acha, Mr. Kyle, the other matter, juvenile, we are posting it tomorrow.
Not,
You please come prepared.
yes, yes,
Give us a sequence.
yes,
This is
yes,
a short matter.
yes.
Only
Lordship,
thing is which of the rules will be applicable.
there are, I am relying on 3 judgments, I play copy of that.
Can you give, you don't have, you give the copies tomorrow.
If required, I,
Which are, these 3 judgments are on which point?
but regarding Lordship, even if there is a difference of 3 or 4 months or 6 months, then in case of heinous crime, the benefit of JJ not be given
So
to.
can you give us the citations?
I'll give it. Sir.
Yes. What
Lordship,
about
In this case, Lordship,
regarding
9 years, 5 months, 9 days, Lordship.
today, Lordship, I am some, I have some difficulty, Lordship, today. Because I,
That they last, Lordship directed to come prepared, just to finish them.
All right, one for you, one for him. We can't help it. One, your other matter, we have accepted your urgency. He is unwell, that's it.
this is the reason, Lordship,
Lordship, can we do one thing, Lordship? My part, complete today, if possible tomorrow, Lordship. It's only,
Heard Ms. S. K. Nardi, learned counsel to the appellant, also heard Mr. S. C. Kyle, learned counsel appearing to the respondent, who submits that due to a sudden health problem, he is not in a position to conduct the hearing of this appeal today. In view of the above, and on the request of Mr. Kyle, this matter is directed to be posted again on the 21st of May 2024 for
there's a iron Lordship.
fixed item, along with the pending IA. But along with the IA, 21st of May,
21st.
21st of May, next Tuesday. This matter we posted next week.
Can it be after that, Lordship?
You decide a date. You tell a date.
23rd or 23rd is holiday, after that, Lordship.
So please tell us a date. 21st, you don't want. Then 28th May, 28th,
Not-
wait, 28th May. Yes, that's all. Yes, Mr. Chaudhary. 6 June. We offered 4 June, nobody is willing.
Some personal
Oh, this matter has been in the, you filed your affidavit. Where is it? Let us see what is there in it.
There is just one thing with the ICP was.
Yes.
Because they have not unequivocally categorically said that both the courses are equivalent, but they have asked me to rely on the instructions earlier provided, and in the affidavit they have stated that the BTech course,
Which is the relevant paragraph?
yes, the relevant paragraphs, Your Lordship, would be paragraph number 5, Your Lordship, at page 237. That the bachelor degree course in engineering is at a national credit framework level higher than the diploma course in engineering. So the curriculum is same. In fact,
Yes.
the system allows diploma holders who have completed 1 year of diploma study to switch also to the engineering course. So otherwise they are all same. But to say that they are in fact same would be a little difficult for the AICT, but the curriculum is the same. But the diploma is at a level
Where
lower.
is that statement that the curriculum is same?
That statement, Your Lordship, we cannot make because it keeps on changing. We have these earlier instructions, Your Lordship. I have been asked to rely upon the instructions as well. Just
Yes.
this was provided to me through email. The last page, Your Lordship, the relevant portion is at the last page. What is this? Uh, in the may I read it out, Your Lordship? It
Yes.
says, since the bachelor degree course in engineering is at a level, next level to the diploma course in engineering, and it is presupposed that bachelor degree holder in engineering is well conversant with the course content of diploma course. Lateral entry to degree course in engineering provide pathways to upgrade
You are
knowledge to
reading from which para?
the last page, Your Lordship, of the instructions. Since bachelor degree course in engineering is the next level to the diploma course in engineering, and it is presupposed that bachelor degree holder in engineering is well conversant with the course content of diploma course.
So this is a part of the instruction received by.
Instruction received from the AICT. The affidavit was drafted and prepared by them at the headquarters in Delhi. So because officially they cannot say that both the courses are equivalent. Your Lord.
Correct, we appreciate this. No problem. Yes,
Lordship, may I assist my lord? In this matter, similar situation, lordship has passed one judgment, my lord. In this matter, this regarding this advertisement. WPC number 339/2023, my lord judgment. I'm just assisting my lord. From third paragraph, my lord may kindly have a look.
control.
May I read, my lord?
Yes,
The petitioner herein has done 5 years MTech course in energy engineering after his SSLC. He had applied for the post of MBI. According to the APSC, the petitioner does not meet educational qualification as prescribed by the advertisement notice that is 25/5/2022. Notwithstanding the same, he was provisionally allowed to participate in the screening test. Subsequently, it transpired that the petitioner had failed to qualify in the screening test, contending that the petitioner neither has the requisite educational qualification as per the advertisement notice, nor he has cleared the screening test. Thus, the APSC has filed an affidavit arguing that there is no scope for considering the case with petitioner. Mr. Sharma, so and so, I have considered the submission advanced by the Land Council for the border side and hence also gone through the materials available on record. Insofar as the educational qualification of the petitioner is concerned, as noted above, the requirement is clearly prescribed by the advertisement notice, according to which a 3-year diploma in automobile and mechanical engineering is what is required. It is the admitted position of fact that the petitioner does not possess a diploma either in automobile engineering or mechanical engineering. Whether the course of MTech in energy engineering includes subject of mechanical engineering or electrical engineering to the extent indicated in the writ petition is correct or not, and if so, whether it can be treated as a substitute for 3-year diploma in automobile and mechanical engineering are matters for the academic expert to decide, and the court does not have the requisite expertise to go into the said aspect of the matter. Suffice it to mention herein that by the own showing of the petitioner, he does not have 3-year diploma in automobile engineering and mechanical engineering. Therefore, it is apparent that the petitioner does not fulfill the educational qualification criteria laid down in the advertisement notice that is so and so. The court is conscious of the fact that the petitioner has higher qualification than what been prescribed in the advertisement notice that is 25/5/2022 insofar as the value of the degree is concerned, and he must also be looking for the suitable employment so as to support himself. However, what is to be borne in mind is that a writ of mandamus cannot be issued by the court to accept candidature of the petitioner if he does not fulfill the educational qualification criteria prescribed by the advertisement notice. Such a direction would not only be contrary to the scheme of the advertisement notice, but would also cause enormous prejudice to the other similarly situated candidate who might not have been applied for the said post because of the non-fulfillment of the criteria, madam.
yes, in this case, he did not qualify in the screening test also.
Lordship. He did not qualify,
But
but
this is
that
not the case.
objection, my lord, has.
That is not the case here.
I'm just assisting, my lord, because the similar advertisement, my lord, has passed this order.
Lordship.
And next week, my lord may kindly fix the matter.
So what else is there to be, what is there to argue?
Lordship, I am relying the Zahur Ahmed case. On last occasion, I have argued my case. Lordship, may I argue today or next day, my lord?
No, if we can't close it today, then do it.
Next week, my lord. Next week, any date, my lord.
Hmm.
I'm relying Zahur Ahmed, my lord, only.
Take down, the petitioner's counsel is present before the court. Also heard Ms. M. D. Bora, Learned Standing Counsel, Transport Department, Assam, and Mr. K. P. Pathak, Learned Counsel appearing for the AICTE, who submits that affidavit on behalf of the council has been filed in terms of the order dated
28/3/2020.
order dated
28/3/2020.
28/3/2024 passed by this court, and the same is on record. Mr.
A. Boro.
A. Borua, Learned Counsel appearing for the APSC authorities, however, has sought posting of this matter again after 10 days on the ground that the arguing counsel, Mr. P. P. Datta, is unwell and therefore has not been able to come to the court today. In view of the above, and on the request of Learned Counsel for both the sides, office to list this matter again on 31/5/2023-24 is a fixed item.
My lord, obliged lordship.
Yes.